Court, Abuja Division, ordered members of the Academic Staff Union of Universities, ASUU, to suspend their prolonged industrial action, which had affected education in public universities. What's the implication of this, and how can Nigeria put an end to time wastages of the young ones as a result of the recent strike, often incessant, that is, strike embarked upon by ASUU? Today, we have some guests in the house to shed more light on this. Kinsley, what?
That's right, Honorable. Well, let's first welcome distinguished Senator Ita Enang. Ita Enang, of course, is former member of the House of Reps, former member of the Senate, and also former senior special assistant to the President, Nigeria Data Affairs, as well as National Assembly. Distinguished Senator Ita Enang is a lawyer. We're glad to have you this morning on the program.
Thank you very much.
We have carried over Dr. Abu Hamisu, who was a moment ago discussing the President's speech at UNGA 77. Dr. Hamisu, glad to have you this morning.
Thank you for having me.
All right.
Well, thank you so much, Dr. Hamisu. Don't worry about Kinsley. Just take it easy. We'll just keep going. All right. Now, let me start with distinguished senator here. The National Industrial Court has ordered the Academic Staff Union of Universities to call up with 7 months, strike and go back to work. Can you take us through this, what are the implications of this interlocutory injunction?
Thank you very much. The order of interlocutory injunction is sequel to the application of the Honorable Minister of Labour and Employment, Senator Dr. Chris Ngige, by virtue of the powers vested in him by Section 17 and 18 of the Trade Disputes Act. The Trade Disputes Act says that whenever there is a strike and the minister apprehends it, the strike shall cease and the workers shall return to work. And he says the act of further says that if there is that situation and it continues, the minister shall refer the dispute to the National Industrial Court. So the minister referred the questions to the National Industrial Court. The questions and the dispute that the minister referred to the National Industrial Court first is for the court to answer whether the Academic Staff Union of Universities first have the right to go or continue on strike when the questions have been referred to the National Industrial Court. Second, whether the Academic Staff Union of Universities or any trade union or members of a trade union are entitled to salary for the period during which they were on strike when they were not working by virtue of Section 43, 1 and 2 of the Trade Dispute Act. The other question is whether the question of university transparency accountability solution, which the Academic Staff Union of Universities are insisting that should be applied in the payment of their salaries, is a question that relates to the welfare of workers and not a question which relates to the rights, duties, and responsibilities of the employer, and not a question that has to do with trade dispute, and whether they can dictate that, given that the entire public service in Nigeria is paid using the platform of integrated personnel payroll, integrated personnel payroll system, information system. No, so when these questions were referred, we as the federal government legal and conciliation team went. We had an application in court. It was tortuous, very tortuous, but finally we were able to. We made the application to court. We served the parties, and the court ruled yesterday that Academic Staff Union of Universities are directed to go back to work pending determination of the issues. And one of the questions which has been very tortuous in the minds of the public, which they say you have to pay the workers before they go back to work. Now, of the government, we are saying the issue is, which we've placed before the court, is let the court interpret Section 43 of the Trade Dispute Act. Section 43 of the Trade Dispute Act, which provides that where the workers are on strike, they shall not be entitled to be paid for the period.
That's an issue in the substantive suit.
Yeah.
So we won't dwell on that.
No, we won't dwell on it.
So just before we bring in Abu Hamisu, again, explain to those Nigerians who are viewers who may not have legal understanding. This is not a judgment.
No.
This is a ruling. And an order has been given of interlocutory injunction. What does it mean? Does it mean that it's again, I know what it means, but I'm just asking you to explain. What does it mean? Is it an order of compulsion? Because we read one headline earlier to say, look, they are rejecting it, they are going on appeal. What does that mean? What governs it?
I'm going to answer what it means, but just briefly to read section 43 of the Trade Disputes Act. Just bear it.
Yeah, but that speaks to the substance.
Yes, sir. No, I'm not. It's just the question the court is asked to answer. I'm not going to draw a conclusion.
Otherwise, yes.
The section 43 of the Trade Disputes Act provides heading special provision with respect to payment of wages during strikes and lockouts. Notwithstanding anything contained in this act or in any other law, where any worker takes part in a strike, he shall not be entitled to any wages or other remuneration for the period of the strike. And any such period shall not count for the purpose of reckoning the period of continuous employment, and all right dependent on continuity of employment shall be prejudicially affected accordingly. That's it. And it also provides for the lockout, that is where the employer locks you out. You are entitled to the period for salary for that period if he locks you out. Now, because your employment is existing. Now, going to the question of the interlocutory injunction. Interlocutory injunction is an order of court which directs you and compels you that during the period of the continuance of the subsistence of this court order, you are to cease from taking any action which this order has restrained, prohibited, and directed, that you are to cease. And it is enforceable, it is in existence until set aside by order of the superior court, or if there are precedent conditions are met by an order of that same court, if it found it had no jurisdiction in the course of it. So it is an enforced and subsisting court order, which does not give you leave or permission to disobey. A court order is live, enforceable, and in subsistence so long as it has not been set aside, and all parties restrained thereby are to obey it until set aside. So nobody has an option in this matter, and it is pending determination of the substantive suit. And that is why his lordship said, and in his judgment and in his ruling, that yes, he is restrained at this stage from going into the substance of the matter, because the issues affect the students, the right of the students, the right of the workers. But at this stage, the balance of convenience tilts in favor of granting the interlocutory injunction. And so the order is valid and subsisting, and all parties are bound to obey.
Appealing is an action.
Yes, if you appeal against that action, against the ruling, you are still to obey and abide until the Court of Appeal either sets it aside, varies it, or in any other matter acts in that order. The law says that the acts of appealing, or the right of appeal, or the taking an appeal, does not on its own act as a stay of execution. And so, unless there is a stay which is not contemplated in this matter, or which has not been effected in this matter, all parties are bound to obey. And of course, part of the law says that for you to take any further step in that proceedings, either going on one way or the other in that court, or appealing and being heard in the appeal, you must not be in contempt, which means that you have to obey the order of the court before your right to be heard in that proceeding can be sustained.
So what you're saying that they can appeal, but you have to go back to the class.
Yes, you have to go back to the class.
Oh, well,
It is quite interesting. Because for me, this is the first time that issues around ASUU is being subjected to the loss of the land by going to court, and this time around, not ASUU going to court, but federal government going to court. And I think institutions are deepened when we put to test laws governing relationship. We live in a country where impunity always drive the process of agitation and everything, and any society that thrives on impunity will know no peace. We are for stable academic calendar. We are for stable progress because we know the role education is playing in terms of grooming the next generation. But we can have a situation whereby you have two behemoths fighting, ASUU behaving like a state. Federal government equally asserting its own position as the custodian of the Nigerian institution. And so when you leave this to the whims and caprices of the actors, what you find will not be palatable solutions. And before my organization, ASUU, declared total strike, it was when the issue of a 6-month salary was raised, that they must be paid a 6-month salary that they've not worked, and federal government say, no, we can pay you because there is a subsistence act. So the natural thing to do is to go to the court and let the court determine who is right and who is wrong. I think it's good for our democracy, and it's good for industrial dispute in this country that you don't just abuse your power, whether as a state or as an employer or as an employee, and that we have a law and this law must be followed. For me, it is something that we need to really.
But Habuamiso, this is not good for the nation. Neither is it good for the direct, victims of those.
Yes.
Thinking about the students, the parents, and the society.
Yes.
Good enough. It's a developmental process.
Yes.
But looking at what is really happening, I mean, it's not really good.
You see, we cannot continue this way. That you go on strike, after 2 months you go on warning strike, after 3 months you go on warning strike, after 1 year you go on strike. If it takes 1 year to sort the process, I think it is better for us.
Are we headed there?
Yes, that is what we are doing. That is what we are doing. Now we have icebreaker. Where we was a stalemate, where ASUU has taken its own position and government has taken its own position, which is worse because nobody is saying anything, and even the vice chancellor that were brought in was not really making any headway. And then the government went to court to say, okay, as the impartial arbiter that you are, these are issues for determination, and we want you to look at these issues and then make a pronouncement, and that is how it's supposed to be. So for me, if this very particular process will sort out all of these issues, for instance, like the issue of OTAS that the ASUU is insisting on, because I'm of the opinion, I'm a member of ASUU, but I'm of the opinion that I've never seen where an employee would dictate the manner that the employer would pay, and the mode the employer is supposed to pay you. So these are issues, and I continue to say this. If ASUU had come out to say it's about our welfare alone, because what I've seen over time is ASUU being the problem and the solution at the same time. And you're complaining that you are not being paid what is commissionable with what you are putting in. And then you went further to tell government that government should price education the way they priced it in 1960 or in 1970. Forgetting that was socialism that was being practiced. It was a mixed economy. It was a mixed economy. Let us be realistic.
Unlike now.
Yes, let us be realistic. And then what is happening is that we are now losing our students to neighboring countries whose educational system is not even as standard as ours. Now,
as rigorous.
Yes, even as rigorous. In NOI posts, a lot of parents and students were asked, why do you prefer going out? Surprisingly, none mentioned infrastructure deficit. None mentioned the quality of education. ASUU strike was one of the first reasons that is given. So, and I am a student of Paulo Freire, the Brazilian socialist, that said, in trying to solve a problem, you don't reproduce the method of the people you said are not doing the right thing to solve a problem, because there will be no difference between you and the person that you are fighting. And so, if we want to make a difference in this nation, we must tell ourselves the only truth. And the truth is, we should be able to subject ourselves to the process.
But let's return to one issue. Again, this is not legal. This is I'm trying to sidestep much of the legal matters because the matter is sub judice in a sense. How what is the decision-making process of ASUU? Because they will tell you, for instance, now, obeying this order by the National Industrial Court, they will say, oh, they're going to have their NEC meeting. At the NEC, maybe they will fix a date and say, all right, fine, this is what we have. We'll be served the court order, so we obey. And then, of course, if you say you're not going to obey, that's contempt. And they pick you up, and then you face the consequence. But in taking a decision to go on strike, they normally will have congresses in the various chapters. I have heard, take a university where you have about 1,000 or even 500 lecturers. You call a meeting of the chapter to decide on an important question whether you would join the strike or not join the strike, and you have fewer than 100 persons who turn up. 50. These are usually the radicals and the hotheads. I'm sorry, I use that advisedly, but this is not meant to insult them. It's the radicals who will say, yes, aluta. So you take that decision and it is binding on everybody, and these are the consequences that professors are crying now that they have not been paid for 7 months.
In fact, that is where we are now, because the ASUU should go back and look at how many people are following them behind. That is how many of the academic staff are in support of this. I will say that about 95% are not in support of it. And that is why you are having a situation where the academics in the medical profession, those who are the academics who are teaching the medical courses, are now coming up to form a union of their own. They have applied, because they came some days ago and said, look, we have a situation where there are no students for housemanship this year because ASUU has gone on strike, and we are not involved because the medical situation, the medical students and the medical profession is damaged, and so they seek to break out. They seek to be a union of their own. Look, the lawyers those who are lawyers in the academics are also coming up with a body of their own. Those who are the engineers and other are coming out. That is to break themselves out of ASUU, and there is a provision in law for bodies like that to come out. So ASUU should go and reevaluate. And again, like what my friend has said that ASUU is behaving as if it is a state. That is one of the matters that was raised. That is the academic staff union. Are they entitled to act as if they were a government, asking and determining how the government should act? There should be a distinction between what you, as an employee rather, can ask. Your right is to be paid in a good working condition and other, but not to determine go into the things that relate to the management of the organization. You don't have to come and act as the government. That's
one of the substantive issues.
Yes.
So we skipped that. Nadabo, you have another question. Abu Hamisu, you haven't responded to this. I mean, Senator Ita spoke about the ASUU organization itself. I don't know what the membership strength is like, but sometimes you also hear comments like there is a cabal that runs ASUU, that they have a succession agenda. Sometimes you say there's nothing wrong with that, but that, as I said on one of our previous editions on Good Morning Nigeria, it appears that the leadership of ASUU is laboring under ideological capture.
Yeah, maybe that is the apt word to use. But again, you see, you cannot use 20th century method to solve a 21st century problems. The world has gone past that. We're talking about education. Education is not as it used to be. Education is costing a lot. And therefore, if you believe that the only way to fight is through strike, and that is one thing I've seen in this country. We don't believe that, okay, we can dialogue. We don't believe that, okay, there is this give and take. Unfortunately, in our Nigerian universities, we are teaching peace and conflict resolution. This is the most unfortunate thing. So,
teaching industrial relations.
Industrial relations. Yeah. So, if, for instance,
we're also teaching industrial sociology.
Yeah. So, and I keep saying this. You may have a very good argument, but if the timing is wrong, what you find is what we are going through now. We're talking about world recovery after a pandemic that wrecked countries. We're talking about insecurity in this country. We're talking about dwindling financial resources. And so, therefore, what we are saying is ASUU should look at these problems and open the schools so that we will fight and run away, as we said in Africa, live to fight another day.
Thank you so very much, Abu Hamis. So Abu Hamis is a public affairs analyst, at least, so we're running short of time. We thank you so much. And then thank you so very much also Senator Itaina, lawyer and immediate past senior special assistant to the president on Nigerian Affairs.
Thank you.
We hope ASUU go back to classroom and then appeal. That's just the way it is. That's the order.
And the interest of the students.
In the interest of the students and the nation, of course. Well, guys, good morning, Nigeria. We thank you so very much also for being part of it. Tomorrow is going to be another day. I'm Yusuf Nagabus.
And I'm Kingsley. Yes, I will also do have a lovely day ahead.